the 11th Circuit Court ruled that medical cannabis consumers should not lose their Second Amendment rights. The case was brought forward by a National Normal Board member and former Florida Commissioner of Agriculture, Nikki Fried, and several medical cannabis patients, including some folks at the our allies at the Florida Cannabis Action Network, as well as the National Normal Legal Committee, which filed an amicus brief in the case that said neither the founders, framers, nor elected leaders of the United States, all of whom had intimate knowledge of the role of cannabis cultivation and consumption in their 13 colonies, took any legislative action to disarm consumers and their right to bear arms. So, for all of you originalists, constitutionalists out there, no one should be treated as a second-class citizen under the law. I do know that recently it came out, Pam Bondi and the Department of Justice want to take their Second Amendment rights away from trans people. And the NRA came out and said, no, under no circumstances do you get Second Amendment rights. The government has held a 1968 federal law prohibiting or possession of sale of firearms to an unlawful user as basically saying that, well, since it's illegal under the Controlled Substances Act, anyone with any history of marijuana use should be disqualified. The Trump administration requested the Supreme Court weigh in on the issue. So this could be decided at the Supreme Court level. We'll see how that all shakes out in the grand scheme of things.